Good day and welcome to Conversations with AARP in the Virgin Islands. I'm Troy Deshabere Schuster, State Director of AARP in this territory, and as usual, as always, it's a pleasure being with you today. According to a recent study, 68% of American adults have yet to create estate planning documents. Estate planning, as defined, is the process of designating who will receive a person's assets and handle responsibilities after a person dies, or should that person become incapacitated prior to death. It also sets forth how to handle health and financial decisions when someone is unable to care for their self. Estate planning documents can include wills, trusts, powers of attorney, and advance directives. Estate planning is essential for protecting the rights of a person to choose how they live. Additionally, there has been a lot of activity and discussion across the country about guardianships. The majority of guardians, both family members and professionals, do their jobs well. Still, there have been instances of abuse, mismanagement of funds, alleged conflicts of interest, and a lack of court oversight. Questions about whether an individual even needs a guardian also have arisen. Today's discussion will focus on all of these issues, what families can do to prepare, and AARP's advocacy efforts to empower people to choose how they live as they age and to lead their best lives possible. So, joining our conversation today is Diana Noel, and she is AARP's Director of Family and Caregiving in our Government Affairs Office in AARP's National Office in Washington, D.C. Welcome, Diana.
Thank you. It's good to be here.
It's a great pleasure to have you on the show with us. We've worked together for several years on advocacy issues regarding family and caregiving. Uh, and so now we get together on this show to talk a little bit more in depth about it. If you can just give us a very, very, very brief oversight of your work on the national office and across the nation, really.
Sure. So, in my role at AARP, I am really lucky enough to work with all of our state offices and kind of see the bird's eye view about what's going on around the country with advocacy efforts, with legislation, what's going on in state courts around caregiving needs with that families are going through and estate planning, guardianship. So kind of get the bird's eye view and the spot trends and see what's going on out there.
Yes, and you're in a unique position because again, you work with pretty much all of the state offices of AARP, 53 state offices in the 50 states, Washington D.C. and Puerto Rico, and you see that from a high level, like you said, getting a bird's eye view, but then also really getting into the weeds with a lot of us supporting our advocacy work in the different states and territories. And so today we'd like to talk a little bit about how you supported us here in the Virgin Islands with our advocacy. And we mentioned already estate planning. So tell us, why is it important for Americans to have an estate plan, and what's involved in estate planning generally?
So, I mean, as you said, Troy, estate planning is essentially just a process for really designating how you want your wishes and desires and how you want your assets to be distributed after you pass away. So it almost always an estate plan almost always involves a will. Sometimes there's a power of attorney document, an advance directive. So all of those documents are put in place for you to essentially designate who you would like to make decisions for you if you're unable to do so, and what those decisions are. So it basically puts your plan in place for if you're unable to articulate what your decision is for your assets.
And there's a real need to educate people about estate planning. So here in the Virgin Islands, AARP, we host regular financial planning workshops. And as part of the financial planning workshops, we always talk about estate planning. and we educate the people that way. These workshops are ongoing now for a few years, and they're very, very popular. We encourage everybody, regardless of your age, but especially if you're over the age of 50, but regardless of your age, you could be age 18 and above, to consult our AARP Virgin Islands Facebook page, see when we're having these virtual financial planning workshops, register for them free of charge, and take part in them so you can learn, because you're never too young to start estate planning, right? Tomorrow is not promised to any one of us. All kinds of things can turn up in our lives that can take us down a very different path than we have planned, and we should all be ready for whatever confronts us, whatever we have to confront. And so tell us, Diana, what about AARP nationally? What kind of resources are provided to help people with estate planning, and how do they come in contact with that?
Well, I think one of the things that you really articulated well was that when you have these workshops, and we have a lot of them across the country, we have information on our website as well. You're having these discussions when you're not stressed, when you don't have to make an immediate decision. I think that's one of the most important things to let people know. Have these discussions early and often, so that when and if the time comes where you have to make some really tough decisions, that you have an idea of what your loved one actually wants, and what their wishes are and what their desires are. So I think that's one of the most important things, is to really have the conversations early and often with your family members, and when you're not stressed out, and to really get the information out there. And one of the best tools that we have at AARP is called a Prepare to Care guide. And it's the guide you can download. It's in multiple languages, and you can go through it. And it actually gives you easy to understand prompts, and just say, okay, well, here's where my account is. You don't have to put the account number on there, but I
Right.
bank with this bank. Contact this person, and I want this money to go to this person. So that it really walks you through the things that you would need, or that frankly that your loved one would need to close out your estate, um, or to make decisions if you're unable to articulate them.
Great, and thanks so much for mentioning that Prepare to Care guide. That's really, really very valuable. For our listening and viewing audience, you can go to www.aarp.org, and in the search window, you can just put in Prepare to Care, and you can find the guide there. Now, this does not give you local resources per se. Okay, it doesn't tell you what resources are available in the Virgin Islands, but it's a guide to help you to think about the resources that you may need, and to start searching out those resources, maybe even before you're in need, whether you're a person who may need care or whether you are the caregiver yourself. So please do consult aarp.org, look for that Prepare to Care guide, and help that as a tool to help you to be a better caregiver, or to know how to articulate what kind of care you may need to a potential caregiver. And so, Diana, what are the potential consequences of not having estate planning documents in place?
Well, I think one of the biggest consequences, that then your loved ones will really be making decisions for you based off of what they think is best for you, not exactly what you want, or what your needs or desires are, or what's important to you. They're going to be making their best guess. And it's not to say that they're awful people. It's just to say that they're going to do the best that they can with what they have. And if they don't have your explicit instructions, then it may not go exactly the way that you want it to go.
Exactly. And one thing that has come to the forefront with some people whom I know personally, who don't have a next of kin, right? And if they don't have any kind of documents in place giving anybody power of attorney, financial power of attorney, healthcare power of attorney, etc., and they suddenly become incapacitated, it's quite possible that the government will take charge of your life and make those decisions for you. Again, if you have no next of kin, like no spouse, no close sibling, no descendant, no offspring, that is, and you have nothing in place, and suddenly you end up very, very sick, let's say in the hospital, unconscious or unable to make decisions for yourself, usually what will happen is the Department of Human Services will take control of your life and make those decisions for you. So it's so very important, especially if you don't have next of kin, to have those documents in place so that the government doesn't then end up making decisions for you. And
Right.
so a lot of times when people don't have these documents in place and they pass on or transition to the next life, then here comes the big question: what about their possessions? So tell us a little bit about probate, Diana.
Sure, but before we get there, I just wanted to just flag something that you mentioned. So, um, I think there it's also important to let people know that with estate plan and documents, it's not a one and done kind of situation where you're like, okay, I did my will, it's done, and now I'm good, for the rest of my life. As things change in your life, you should update your will, update your documents. So if you um, get married or have a divorce or you buy another property or a house, then that's the kind of things you need to update the information on your estate plan and documents. So just wanted to flag that as well. So probate. So probate is that's the process. It's a legal process for settling your estate and distributing your assets after death. So simply put, it's just probate laws. They govern the transfer of property after death. So you have your plan, and then the plan after you pass away, then it goes through what's called a probate process, and that usually involves the court systems and um, having things laid out can make that process a little bit easier. So just it's I know a lot of people hear about probate and what does probate mean? Could it be daunting? Yes. Could it be just stressful? It may be, but the more prepared you are on the front end makes probate easier on the back end.
Right. And the goal is to keep it out of probate, by having a trust or other documents in place to make sure that your property doesn't even end up in probate, because that could be such an expensive and lengthy ordeal for your descendants. Um, just jumping aside for a moment here, looking at the questions from our Facebook Live, we have a really great question, and
Sure.
this is: should you put all your children on your estate, or should you just put one? So I'll let you take a stab at that, and then I may add a couple of comments there too. Go ahead, Diane.
Sure. So I think honestly, you should probably sit down and have that conversation with an estate planning an attorney in your area that knows your laws and knows what all would be involved with how many um, people you put on your documents, and to be really frank, your children.
Yes.
So you my mom says this all the time, so I'm just gonna, be really frank. Um, my sister and brother and I, we all um, have our strengths and our weaknesses, and there are things that I'm better at than my sister, and things that she's better at, and vice versa. Same with my brother. So my parents have been very open and honest with us about which ones they know would be able to handle their property and be able to navigate all of that after they pass away. So this is why these discussions are important now. I think that's, like I said, just have it when you're not stressed out. When it's just a conversation. I've taken the prepare to care guide to a family reunion before, so just I would just say that's a personal preference, but definitely walk through and have those conversations now.
Yes. Very good point. I like what you said, that a parent knows their child best, right? And that's so important. But just to review quickly, when we talk about estate planning documents, we're talking about power, healthcare power of attorney, financial power of attorney, living will. Living will meaning what kind of treatment do you want as you approach the end of your life? Do you want extraordinary means? Do you not want extraordinary means? Do you want to be resuscitated if you go into cardiac arrest? Do you not? Et cetera, et cetera. Um, and so I always tell people, first of all, think about which one of your offspring you find to be most reliable, as Diana alluded to. Furthermore, which one of your offspring is most accessible, right? If you have a very responsible son who's living in Australia and you're living in the Virgin Islands, it may not be good to give him power of attorney because he's so far away. He may need to be here, right? Maybe he could do it from a distance. I don't know. That's up to each individual to decide for themselves, depending on their particular set of circumstances. But just looking at all of the different factors, I know that some people do the added safeguard of having one offspring having financial power of attorney and another one having healthcare power of attorney, right? So you don't have the same person making your healthcare and your financial decisions and so forth. So all these things, again, you can discuss with your attorney or somebody with whom you have a friendship who has knowledge in these areas, and then make your decisions as you go along. So,
Yeah. I would just add that one thing that's also something that you walk through with the attorney is there are some situations where someone would put, and this happened with in my family, where they put both children on the financial power of attorney document as agents, but they were co-agents, and one couldn't act without the other. So those are other safeguards that are built in as well, and something to discuss.
right. Or having a primary and a secondary,
Hmm.
because you could do these documents and then, God forbid, maybe your offspring passes on and then you become ill and then you don't have a secondary, right? So it's good to have a primary and a secondary also. Lots of things to think about in
Yes.
this arena. And so here in the Virgin Islands, AARP has been working hard in these areas to develop legislation to ease the issues regarding guardianship and also probate. So, Dan, if you'll tell us a little bit about this major bill that we had enacted here in the Virgin Islands called UAGAPSHA, which is a Uniform Guardianship and Protective Proceedings Act of 1997. Big term, but make it simple for us, Diana.
I'll make it simple. This is the easiest thing. Is this? This is a act with a long name, Uniform Guardianship and Protective Proceedings Act, and all it means really is the act really outlines and clarifies the role of guardians and of the courts, the process of guardianship. And I know we haven't really jumped into what guardianship is just yet, but that's what essentially the act does. It makes that process clearer for all that are involved, and clarifies the roles for individuals that are involved in that process.
Excellent. And as we continue on discussing these, I just want to make it very clear to our listening audience that here at AARP, we are not offering legal advice. We're not offering legal advice. Again, please do consult your attorney with all decisions that you make. The only thing we're doing is encouraging you to think about estate planning and to discuss it with your attorney. So please do that. And again, remembering that at AARP we do not give specific legal advice. We're an advocacy organization, and we work hard to make sure that people have all the tools to choose how they live as they age. And so, again, talking about probate now. So we mentioned a little bit about guardianship, but back to probate, the big topic. We enacted or had enacted some very specific laws to help people keep their property out of probate. And probably one of the most popular ones is the Real Property Transfer on Death Act. So explain that to us, Diana.
Okay, so the 30-second summary of that act is quite similar to what the guardianship one did. That act actually does clarify the process for transferring property after someone passes away. So that prior to the act, I know you're wondering, well, why do we need it? Well, you need it because there were a lot of moving pieces and things that weren't quite clear, and it ended up having families in the probate process for a very long time, and it got really expensive. So this act actually helps to ease that process, make it a little bit faster, and passing on property after your loved one passed away.
Yes, and here in the Virgin Islands, it's very, very easy to do that. So what you have to do is execute a real property transfer on death deed. And the recorder of deeds here in the Virgin Islands, they're well aware of it. People are already making use of this law. I confirmed it with the recorder of deeds here on St. Croix. And so it's a simple process, which with some guidance you could probably do on your own. But again, it's probably better to have an attorney do this real property transfer on death deed for you. And the good thing about it is that when you designate the beneficiary, the recipient, the heir of your property, using this real property transfer and death deed, you still have full control of your property. So if you want to sell it, you can do so without that person's permission. If you want to mortgage your property, you can do so without that person's permission. If you decide that you no longer want to leave your property to that person for whatever particular reason, you can remove that person's name from and just totally, negate or do away with that real property transfer on death deed. Sorry, as I struggle for my words there. And so it's very, very easy to execute. And once you do that, your property will not go into probate. And remember also, listening audience, that even though you may have a will, your property would still go into probate if you don't have a trust and if you don't have a real property transfer and death deed. The will kick in to play after your property is probated. So again, please consult your attorney about all of this, but it's a great idea to have a real property transfer on death deed in place. Also, Diana, I know that we did a bill regarding digital assets. Discuss that with us.
So this one is fairly new, and I have to say that the Virgin Islands is actually on the cutting edge with enactment of this act. So it's this bill is called the Uniform Fiduciary Access to Digital Assets Act, and what this means is it essentially develops a process and procedures for what happens to your online presence and your digital. So some people have, we have Facebook. We're on Facebook now. So their Facebook account. Who has access to your Facebook account after you die, and what does that mean? If you look in your settings, you might actually find something about who have access to your account afterwards. So that also translates to email. What happens with email? Who has access to your email? If you're like me and you have all of your passwords saved on your phone, that's a digital asset. So who have access to your passwords for your bank accounts? Like, you're establishing and setting up these documents, financial powers and everything else. But if your password to your bank is in your phone, does your agent have the authority to access your phone to get the password so that they can close out your estate? So this act help kind of ties in and figure out who has access to your assets and what type of access do they have to these accounts and to email. Can they go through all of your email, or just the emails that are relevant and from your bank? So that's what this act is about. It's fascinating just to read through it. And I'm one of those people that like to read this kind of stuff. So it's fascinating. So if you think about your digital presence, who has access to that after you pass away, or if you become unable to share your wishes? Who can access your documents so that they can help make these decisions and for you, and based off of what you want them to do?
And especially as we're living more and more in a digital and a paperless world,
Correct.
right? So you could be having all of your bank statements, everything coming to your email, and your loved one may not even know what bank accounts you have because nothing is coming in the mail. They don't even know where your money is. And so it's important for them to have access to your digital assets, right? So they can handle your affairs, close out your estate. But even again, if you're still alive and become unconscious or incapacitated, and they need some money to take care of you, how can they even find your own money? Like, where is it? Again, um, having financial power of attorney is one thing, but then knowing where to go to use that financial power of attorney is another thing. So
Hmm.
again, if they don't know where your bank accounts are, they don't even know where to go to actually use their financial power of attorney to get money to take care of you, right? So it's
Correct.
it's all very interrelated, and so very important to do. And so we have just about 3 minutes left, and I know we have some exciting ones coming up about electronic wills and electronic notary. Just tell us a little bit about that really briefly in the next 3 minutes or so.
Sure. So as we just explained, tying into the digital world, so the past year has really shown us how virtual and we really are. And one of the things that was interesting that happened over the years that people were trying to create um, wills and but they couldn't because the state laws said that they had to execute the wills in person. So there's an act that we're working on now that's called the Uniform Electronic Wills Act that will allow you to execute, create a will, update a will virtually, electronically rather, and to also. So then once it's done electronically, then how do you get it notarized? Well, that's the other act. It's like, okay, well, I want to get my will notarized. How do I do that? The other law or notarial acts would allow a notary to notarize your documents virtually as well. So there's a lot more detail in there, and I'm going through in 3 minutes. But I just want to make sure that people understand that your laws are being updated and they're trying to go with the times and trying to make sure that you can still have peace of mind on paper and virtually as well and electronically. So that's the thing that we really want you to understand. This does not replace a paper document. Let me just make that very clear. This is in addition to. So we're very excited about these two.
Excellent, excellent. And again, ladies and gentlemen, we're not giving legal advice here. We're encouraging you to seek legal advice and to discuss all of these matters of estate planning with your attorney and your financial advisors. Very important things for you to consider, especially as we continue to age day by day, each and every one of us. Please do consult our Facebook page, AARP Virgin Islands, and also our local website, aarp.org/VI, to find out more information on our local advocacy. Also, look at aarp.org, Googling or searching out in there, sorry, estate planning, and see all of the documents that we have there, especially about our Prepare to Care guide. So, Diana, thank you so much for being with us today and discussing this. We hope to have you back on a future show because we have so much more to discuss, a very rich topic. Again, thank you so much for being with us.
You're welcome. Thank you for having me. I look forward to further discussion.
Great. Have a great day.
Too.